No, right? Because you don't. I don't look as an objective matter. I don't think you necessarily have a duty to make somebody else's stuff accessible in that context, especially if it's. This is a very emerging area of the law, right? These cases have picked up steam in the last 5 years or less, right? In terms of accessibility websites. I mean, now if you were, say, you were a contractor building a building, then you might have some duties there that are a little bit more explicit, right? Because local building codes would tell you what things have to be in terms of accessibility, or having a handicap parking space, right? Maybe you have duties there to make sure those exist, even if your client doesn't expressly ask for them. Yeah, you may have a duty, but I wouldn't take that too far. As far as website accessibility goes, it's a very emerging concept, and I wouldn't think you have a duty until there's some real concrete case law, right, from courts on the subject. And they're all over the place. We'll talk a lot about that. They're all over the place as to what's actually required. And there's no written rule that says, for example, I'm sure Christopher uses like WCAG, which is the common one, WCAG 2.0, which sounds like a perfectly good, fine, but these are not enshrined in law anywhere. There's not something from the Department of Justice that says you must use this to comply. In fact, the Department of Justice doesn't even say you need to make your website accessible at all, right? So
yeah, there's nothing. I mean, the legal precedent is not there yet. But again, this is where I do believe that there should be some checks and balances, because there are people who are going out there without, I mean, they have probably the best intentions, but they're just trying to make a quick buck too. And they don't have the capabilities to build a website that is accessible, that is making those considerations that, again, they should just be second nature at this point. But yeah, to answer your question, yes, I use WCAD as one of the tests, and then there's also the Axe accessibility plugin as well. I cross-reference both of those, and again, a lot of this has to be put on me as a designer and developer as well, because as Andrew, you pointed out with your very own website, you have some red flags up in there. There are, and there is, and there always will be gray areas in terms of what is accessible and what's not accessible. And there is a lot of discussion currently within the design community, specifically regarding color selection and contrast, because if you desaturate colors that will get flagged in WCAD, for example, there's vibrant reds and vibrant greens that when you're desaturated, they don't meet the contrast requirements for accessibility requirements. But if you ask and they've done these tests, I don't want to have the references right off the top of my head, but they've done user experience tests with people with vision deficiencies that specifically apply to those contrast considerations, and they have no problem seeing the contrast, where they actually have problems with other things that don't get flagged in WCAD. So it's, as you said, it's a developing situation, but at the same time, there needs to be, some people will just select a color because they're like, ooh, hot pink is pretty and it's great, and there's no consideration for contrast whatsoever, even before we get to the WCAD considerations or the Axe testing. So that's for me, again, I think there needs to be some sort of, not proficiency test or not, again, it's a slippery slope, but as we talked like a little bit earlier, kind of bleeding into the call with Lori, with Shopify, for example, I think there needs to be some kind of checks and balances that doesn't hinder the creative liberties of their platform, because then again, you become a walled garden. You prevent designers from being able to customize themes and do things that are really going to benefit the custom ecosystem that you're trying to build for that brand or that client. You don't want to prevent that. You don't want to become a walled garden that prevents that, but you also want to have those validation checks and balances somewhere in between deployment. That just, I mean, in my opinion, that would be something that they could bake into their pipeline fairly easily. With every change that is deployed or saved to a Shopify website, it runs through something like WCAD or an Axe checker, and it just says, hey, did you know? Because again, a lot of these designers and developers, they may not be as seasoned as some of the other people who actually know to look for this stuff, and they are more cost effective. Again, everyone has their own used car salesman analogy for any of this stuff, but you can pay more and get someone who's going to take that into consideration, or you can, again, if you need a budget friendly solution, ask them out front, do you know to look for that kind of stuff? And if they don't, maybe you just run the test on your own and say, hey, I see this didn't pass the test. Can you fix this for me? And these are, they do spit out, each of these validators, they do spit out very clear, understandable, it's non-code jargon. It's not stuff that anyone's going to get confused by, like, oh, what is this broken validator? I mean, usually it really is contrasts, or Andrew, like you said, things that aren't as serious with regards to headline, using a H1 tag, for example, or not using alt tags and images. Basic things that, I mean, you can copy paste that stuff over to your designer or developer and say, we're not passing. Like, can we just fix these issues? And you can kind of patch some of those low-hanging fruit fairly easily. And again, this gets into the weeds a little bit, but once you start customizing templates or themes or other things like that, you start breaking the foundation that most people do try to, when they're selling a theme, they try and tout its accessibility. But once it gets modified by the designer and you ask for your pretty pink or whatever as a client, those things can very easily go downhill.
So I guess a good question for you, because I mean, and to everybody here, I guess it's time to introduce our speakers. Andrew Connors we're very, very blessed or fortunate, depending on your preference for terms, to have an attorney here who actually can speak to the legal issues that are involved. And Christopher Ray is a extraordinarily talented developer who has extreme experience. And one of the things you'll find if you've been out there looking at developers is they're really, I mean, this isn't an area where the developers necessarily have a ton of answers yet. There are definitely some who know their stuff, but most of us are still learning. So it's kind of an interesting space that's evolving. And Andrew, you started out in the beginning. Can you go back through your discussion of what's going on and where the legal state of this issue is today?
Yeah, so perhaps, yes, I'd love to, and thanks for the question, and I'm really happy to be here talking to y'all. And I give you this context of, I'm more of an intellectual property and technology law type person. I used to be a software developer before I went to law school, and now I teach some of these subjects. So 9 months ago, I didn't know very much about the ADA, other than if you're building something, talk to your builder probably knows certain requirements, right? But this website stuff was all really new to me until one of my clients gets literally like a 6-sentence demand letter, which is, sorry, hopefully you all have never gotten a demand letter in the mail from a lawyer, but that's facially absurd to get a short letter. And the letter doesn't even have money involved. It just says, we are going to sue you. If you have a lawyer, you might like to contact us. So that's how I start learning about this and this practice. So the law, right, in general, Americans with Disabilities Act says if somebody has a disability that's defined under the law, it's not any disability. It's a disability that affects your day-to-day behaviors, right? So if a disability would affect your ability, a disability that affects your ability to physically get around, that's a disability under the ADA. Something more mild that we might call a disability might not legally be a disability under the ADA. So it's important. So with website accessibility, right, you're usually dealing with people with sight problems. Perhaps they're blind or they're colorblind or they have some other sight problem where they have issues with seeing what's on the page. And so these cases revolve around whether your website can be fed through a screen reader that can be understood by that disabled person. So that's right. The law in principle says if you've got this disability, then you can't have a barrier that restricts access to the underlying goods and services. That's how I view the law. That's how my client, who's defending a federal lawsuit now, views the law, and I think that is the law. Where there's a trick, of course, is, in my view, and this is in flux, right? The arguments that are getting put forth in court all across the country, because these demand letters are ubiquitous. These are getting put out by what we call litigation mills. In other words, the firm I'm working in is well known in that this is a templated letter I got, and they just changed out the URL. The complaints are the same. So the legal term we use is a complaint of the document that starts the lawsuit. They're all the same. I've got 20 identical lawsuits filed on the same day as my client's lawsuit. And the only thing that changed was the defendant and the website. That's it, right? And so what they're looking for basically is you don't pass the checker What they say is, so if, for example, one of the things that are in the lawsuit I'm defending, it says there are redundant links on the page. Redundant link means a link appears more than once, right? Now, that's not per se illegal. It has to be a barrier to prevent access to the goods and services to be a violation of the ADA. The reasoning employed here, and I think it's kind of, it depends upon the circumstance. The reasoning is if somebody puts that through a screen reader and they see a link appear more than once, a visually impaired person may be confused as to why the link is appearing more than once. That's sort of the rationale. I don't think it's a particularly good rationale, but these are the things that these lawsuits raise, right? They in some sense, they might be very deep issues, right? You might have a Flash website or something that really might be hard to run through a screen reader. But then the things I'm describing, like a redundant link, I don't think those things are actually barriers at all, right? They don't actually inhibit the use of a screen reader, and that's what one of our defenses is. And unfortunately, where the law is going is there's no guidance. So the Department of Justice has to implement this, and they don't have any guidance about this. So they don't say what standard ought to apply. They don't even necessarily say you have to do this. The other issue you have that's significant and is sort of the thing that's getting fought about now is, do you have to have a physical place? Does the website have to be tied to a physical place? That's a substantial area of debate, and cases go both ways. And then another significant issue, as I'm kind of alluding to, is it even a barrier? Or maybe is it a barrier? Is it only a barrier if somebody brings it to my attention and I refuse to change it? Right. So those are all significant issues I could tell you a lot about. I'd love to tell you more about that case, but I don't want to hog all the time. So there's what the ADA says, and then there's what these plaintiffs that are bringing these sorts of lawsuits are saying. And I think they're two different things.
This may actually be a better question for Christopher, but can you give some guidance as to what it can actually cost to remediate a site? And is it cheaper to just start over?
Oh, in terms of actually I thought you didn't mean in remediating in terms of the legal aspects. Again, in terms of building a website, that could vary depending on what specific functions your website do. If it's a small informational website, like Andrew said his is, yeah, it'd probably take me, a couple hours to build, something like that. If it's something more e-commerce oriented, again, we have a lot of, as you know, Lori, a lot more to consider, a lot more facets to consider with regards to the infrastructure and the requirements for that specific business. Again, how they're doing business plays a big role in that, how they're what types of products or services they're selling, how they're taking those transactions, what payment processor, a lot of things to consider there. And again, this, in terms of building out the website, it really depends. It's funny that Andrew brings up that specific issue, because I have seen that one flagged in WCAG before, specifically from a navigation bar where you have your home logo as the home link, and then it appears, you have the home, it goes logo, and then it says home, services, whatever. It appears twice in the same row because it's both your logo and your home link. So I've never seen anything fought. I mean, it's very interesting to me that he's got litigation pending with that, because that's, in terms of, just me objectively looking at the web, that's all too common. I mean, it's on virtually every website. And again, that's a very conflicting thing also, because you say, if from a usability perspective, it's very well known that if you remove a home link from your navigation and you only have your actual logo be the home link, then you're doing a disservice from a usability perspective there. But if you also don't have your logo be a link to the home, which is another intuitive thing from a usability perspective people look for, it's there's really no, it's a lose-lose situation, I guess, in terms of that specific thing. And that's where I say you need to look, there needs to be some kind of checks and balances, but it ultimately needs to be, with good intention from the developer, saying, is this going to prevent people from using the website with, from this usability perspective, screen readers, or people with vision deficiencies, et cetera, et cetera. I mean, again, that just should be a standard operating procedure at this point.
Cool. I guess, so there's some good questions coming in here. So where should store owners start? I mean, I noticed there's a lot of free testing tools out there. They seem to hit a page at a time. is that worth their effort to go through and test and find the flags? Is that even going to be considered adequate when you consider things like?
Yeah, absolutely. I think every business owner, especially just the fact that they're here doing their due diligence on this subject, shows that they're willing and able to learn. And again, this is not something that is, in terms of just direct translation, you're not speaking code, there's no translations for using either the WAVE accessibility test, which is one that I use, or the WCAG, isn't WCAG, it's people call it WCAG, you can call it whatever, but WCAG is the one tester, and then Axe is another tester that is a browser plugin, depending on how proficient you are with browser plugins. Doing the test is not rocket science. It's going to spit out some information. There'll be varying levels of deficiencies, I guess is the best way to say it. There are different levels. There's A, AA, AAA, and again, that goes all the way from like low grade is A. You don't have it's not as usable by the WCAG standards, but all of the errors and warnings and things that it's going to spit out are things that you can copy paste directly to your developer and say, hey, is this something that we should be concerned about? And again, that's something that even before you send it to them, you do a quick Google, but depending on what it spits out, lots of the times, like Andrew said, it's headlines, it's missing alt tags, it's links are too small is a big usability one that people miss all too often, specifically with like little social media buttons, because those can become very small and people are like, they want them to be up in this top right corner or something, and they want them to be 15 by 15 pixels. It's not adequate for a mobile device, not adequate for a lot of solutions with, it's not a problem with screen readers, obviously, because they just read through the page top to bottom. And so again, that's another thing that you can do on your own. Most phones these days ship with a screen reader. Just pull up your own website, turn on your screen reader, let it read through your website. And if it reads something double and it sounds super weird, just close your eyes and listen to it. If it sounds super weird, it's not intuitive. I mean, it's something that, lots of these things that are coming up and being flagged, and again, most of them being litigated, especially from my experience on the political spectrum, most of the litigation that does come through is just really small, clumsy stuff. I mean, it's things that people should have never missed to begin with. And it's whether they're bigger, like 501c3 organizations that I've inherited that were rebuilding their website, for example, and their donation button was a hot green because some person in the spectrum told them hot green is the best for getting donations. None of those things were ever with a white text on top. It was hot green with a white text. It's never going to pass. Those things are, again, it's going to get flagged. You can easily bring that to someone like myself or anyone else and say, hey, it's not accessible. It clearly says it's at 20% contrast ratio, which my brain tells me that if I have a color blindness, for example, that contrast for a green might not be sufficient enough for me to read that button. That's all too common. That's what I see most often being litigated from the political perspective. But again, running it through a screen reader is something that everyone can do themselves as well, and along with these other tests. And it's not jargon. It's not something that's hard to understand.
Andrew, what about the accessibility statement? Is that something somebody could put up right away that indicates they're in the process of improving their site?
So you mean, Lori, like a statement that would say, explain what you mean by an accessibility statement, just so I make sure I'm talking
and
about
I think there's actually a better name for it, but it's basically a page on your site that indicates that I may actually be able to find one, but
I know what you mean, right? So you mean
yeah.
some sort of statement where either that says you're working on making it accessible, or in fact, it is accessible, and maybe even gives people alternative links to click on for accessibility.
And a
access.
phone number. I've been told you should have a phone number that they can call. In fact, one of my clients was told it should be a 24/7 phone number, and he said, no. He says, I don't offer 24/7 phone support to anybody, is what he said.
Yeah, and these are great questions too. And I almost think so from a risk management perspective at first, right? Again, I want to keep emphasizing sort of two issues. One, there's what I think the law actually requires versus what's actually going on. When are these plaintiffs suing people? And forgive me, and I say this also from this perspective of defending a longtime client on this. Some of these, like I said, are what we call litigation mills. They're high volume, and
Delete.
I don't know if there's any way to ever solve it, right? In other words, what I mean that by solving it is I think you're complying with law, but you're still going to get sued, right? Which is unfortunate, but I think it's the truth, because that's what's playing out in the case I'm dealing with here in Roanoke in Virginia, where I am. But one thing I keep thinking about, I think everything Christopher said was great, because really from a risk management perspective, I'm not sure if it's so much complying with law so much. It reminds me of the adage of, what if me and my friend are camping and we run into a bear? I don't have to outrun the bear, right? I have to outrun my friend. And so if you're going through the checker and you're fixing these things, the checker is what these people use so that the lawyer who's filing this complaint, which I'm trying to be transparent. I don't have a lot of respect for a lot of these lawsuits. I'll try to keep describing what I have going on in this lawsuit, but they're extortive, right? The whole purpose of the lawsuit is to get a payment. They're not to fix any alleged problem, right? At least, no, I'm not saying every lawsuit. I'm saying this species of lawsuit that I've described to you. So I think, though, with that said, you're not going to get on these people's, the plaintiff's radar if you have gone through the checker and you've changed things so you're not raising the flags. Now, that said, these flags we've just been talking about, some of them might be they're somewhat speculative, right? If you don't have this particular feature, perhaps it makes it inaccessible. But you actually, from a legal standpoint, right, it's only inaccessible if it is indeed inaccessible. If you have an actual sight-impaired person that visits the website, that wants to buy the products and can't buy the products, that's it. Now, as to that accessibility issue you mentioned, Lori, that's an interesting problem. I would agree, and I think the Department of Justice agrees, that giving an alternative, like saying, if you're having problems, please call our phone number or email this address or use some other alternative. My client has an order form you can use for his website. Now, the order form is interesting because maybe it's not accessible by a screen reader. But my point is, maybe you give some alternative that's simpler, where you don't have these problems of what gets processed through the screen reader. I think that's absolutely a great idea. The Department of Justice says to do that. If you go to ada.gov, they have a guide of what you should do as a small business for helping, or any business for helping people with disabilities. And one example they give is, suppose a blind person comes into your restaurant and you only have printed menus. Well, you're not violating the ADA by having printed menus. You're violating the ADA if now you don't help the person read the menu, right? You read the menu to the person, you help them make an order, and now you're fine. Unfortunately, one of the claims that's coming up, and it's coming right now in the case I'm litigating, the argument they've made, and I think it's absolutely incorrect, is that by offering an alternative means of access, I am harming my client is harming the personal dignity of the plaintiff because we're making them use, it's almost like a separate but equal argument. I don't think that holds any weight, but that's the argument that's being raised, that you shouldn't have alternatives, in fact. And that's really disappointing because I don't think that's the law at all. And part of the problem that the business owners listening here have to wrestle with, I think, is that those sorts of arguments, in my estimation, are made not because they're really great arguments that a judge is going to agree with. They're made because it costs me time and money and my client time and money to respond to them. And why not pay off the plaintiff rather than paying me to respond to them, which will cost more, right? It's complicated work. So I think that's unfortunately the state of things, is that there's a lot of litigation going on. There's no clear standards from the Department of Justice or Congress. And so it's cheaper to pay the plaintiff than to actually just fight it out, even if you have great defenses, as I think my client does in my particular case.
Yeah, that's my understanding, is that there's basically we're calling them ambulance chasers, to keep it polite, that literally have probably Filipino VAs that are running through site after site after site looking for these violations and milling out letters for claims that may not even be legitimate. But of course, setting foot in a courtroom is always expensive unless you happen to be the lawyer. And most of us are not.
I always win. I get paid. You don't, right?
Right. Well, I mean, I used to joke, if I'd known how much time I was going to spend in divorce court, I would have gone to law school and at least gotten paid for it. Man, I've only been divorced once. So, It's kind of insane, and for, like I said, for a couple of these small businesses I know who've been hit with this, it's emotionally devastating and sometimes financially very hard to cope with. So I guess I mean, we have a bunch of good questions here, but one of the questions I have for you is that, is there any what about, I mean, I see quite a few companies actually selling what they're defining as solutions. One I think is UsableNet, and they actually produce the mirror site you were explaining, where there's a link in the top corner that goes to a different version, which would obviously didn't work for your client in terms of offering a separate but equal experience. And obviously, if you've designed something that's truly visually amazing, you may not want to have to sacrifice that, which is really kind of, I mean, maybe that green button is what you really want because it works so great for your branding. And suddenly you're having to change that because it's not good for people with color blindness. And then there's the popover widgets, some of which are free. And I understand the free ones are pretty close to worthless, but even the paid ones, it's my understanding that some of them are being actually targeted for lawsuit. The users that are using UserWay or Accessive as two of the I mean, they're in that space. They're well respected. I'm at the point where I always thought that was a great way to provide immediate support and to show that you are trying to get towards full compliance. And then I'm finding out that use of those tools is making people a target, and I don't know what to advise people to do.
Well, I think, I mean, aside from answering your specific question about what to do, I think what you're alluding to with regards to the style and brand questions, again, some of that will fall on many clients that I've had. They specifically ask for things that are inaccessible. So, and even with my strongest urges to do another solution, some people just don't really make those considerations until, like you said, it's too late, Lori. So again, that's one of those things where I can do my best effort to, as a professional, recommend even, and again, this is something where it's subjective versus it's a subjective decision for that client to say, I really want that hot pink or hot green button with white text, versus an objective observation and something that is tried and true from a tested perspective not to work, that we can still, any good designer is not going to say, oh, this is the only color that's going to work and that's it, and green is the way to go. That's like old news. Again, that's one of those things where there's, not only could you test that theory from an A/B perspective, which is last month's conversation, not only could you test that, you could really, I mean, definitively say that that green button with white text probably isn't doing you any good anyway. So not only from an accessibility perspective, but again, outside of doing the checks and balances, I think there needs to be some responsibility on both. It needs to go both ways. The developer needs to flag it and say, hey, theoretically, the developer should flag it first, but I'm guaranteeing a good portion of the people on the call will be some of the first to go and illuminate some of their development team. Again, it just happens. It's a new and emerging area of the development spectrum. That's why we're having this conversation. But it's been my pet peeve forever since I started developing websites, because I feel like it's just having something be intuitive should be the designers it should be in their nature. I mean, that's why someone is hiring us to build a tool to facilitate those conversions. You're not hiring us to paint you a pretty picture and say, oh, it looks really nice, it's something I'm going to hang on my wall. That doesn't do anyone any good. And that's where I think we need to start looking at websites much more functionally in a way that is more of a tool. Because again, I think Andrew could meet this analogy. You can't build a tool for someone that isn't accessible for a lot of different people, from just a normal everyday, you walk into a store, and use a fountain drink kind of thing. Something that is accessible for everyone. Again, blindness, maybe not, maybe that's, I don't know exactly where that gray area falls from a legal perspective, but just building a tool that is trying to get the most chunk of your sales possible, that just sounds like second nature to me. I mean, I feel like that's why people would hire me as a web designer, is because I'm trying to get the most sales possible. And by, you know, making a button a certain color or doing something that's inaccessible, whether it's from screen readers or otherwise, just seems like a disservice to that client. I mean, it just doesn't make sense.
Well, and I, also as a dev firm, I agree with you wholeheartedly, and that's one of the reasons we're not the cheapest on the spectrum. I know there's at least one, if not two people in here today who can attest that when they came at me with their original design, now we didn't deal with accessibility in particular, but just overall in making sure that site design was designed to help them sell more product, which is the whole point to investing and setting up a business. But and from an ethical standpoint, having a site that's available to everybody who wants to shop from you is good business. Unfortunately, the pulling together of an accessible site can be expensive, and that, you know, from an I mean, I'm finding issues with forms, but I mean, the biggest issues I'm running into are the forms, the images, and the videos. But I don't even know, for example, there's a wealth of third-party plugins that do this pop-up and do that and add upsells and all kinds of stuff.
I think you bring up a
I
good
don't even
point
know
there.
what happens with that.
Yeah, and again, I think you bring up a good point there. Again, that's starts with the foundation of the web development architecture that you've chosen. Again, this is why I'm a big proponent of Jamstack right now, because it's a less is more solution to building purpose-built solutions for your clients without all of the additional bloat that comes with choosing something like WordPress and a theme or a framework for that matter, which a lot of people are doing these days are pimping out themes or pimping out frameworks where they modify these things without the accessibility considerations, and they start digging the hole 6 feet deeper. That's where, if you purpose build a solution on top of a solid architecture that is accessible from day one, and you make all of the accessibility at every turn, you make every accessibility consideration possible, you're not going to run into those issues. It's not, again, I'm here to say, like, I can attest to, you know, from building out a website, I'll always come across issues at the end of the testing phase. Sometimes they just kind of slip through the cracks, whether it's a contrast or a button size kind of thing. And that's where you can fix small things. But if your list is really long, 90% of that's going to be coming from a bloated framework or a theme or something that just wasn't taking those accessibility considerations. Because again, if you look at the theme market, for example, for WordPress, a good portion of those themes don't tout accessibility. One, because they might be 5 or so years old at this point, which accessibility wasn't even like a buzzword at that point. So I think really it's only coming to fruition now in the industry where people are like, oh, our theme is accessible. But that's up until you hand it off to an incompetent developer or designer who's going to start just chipping away at things that they don't know about, and then it breaks.
Yeah. Well, and I think most store owners have to balance cost, you know, so that becomes part of the equation. It's features, its functions, its cost, and I will say, from what I've seen, which is certainly limited in scope, it's cheaper to build it right the first time than it is to pay to deal with it when you get the demand letter. Just to be aware. For either one of you, what has changed, and this is probably more Andrew, but what has changed in the last 6 to 12 months, and is there a good way for people to stay aware of what's happening?
So I'm going to put a link in here for everybody to see, in case you want to do what I do every day, reading court cases. But that's a significant court case. It's called Robles versus Domino's Pizza. That's the case that started a flood of litigation of this kind. It occurred out in California, and that's a decision from the Ninth Circuit Court of Appeals, which has jurisdiction. It's an appellate level court. It's just under the U.S. Supreme Court, and that is all about accessibility of websites. So that really changed a lot of the legal landscape, because up until, it's not like these issues didn't exist for the past 3, 4, 5 years, but people cite that decision now to say you have to make a website accessible, because up to that point, the conventional wisdom was, and I actually think this is still correct, but we don't have any this is all in flux. In other words, we don't have a higher level court saying what I'm about to say one way or the other, which is that conventionally people thought of this as physical access, right? Because these are, you may have heard the term, legal term, public accommodation, right? You have a public accommodation, you can't discriminate, right? It started, of course, very correctly with dealing with racial discrimination, right? And then later the ADA came along and it's the same body of law. So with public accommodations law, if you actually read what's in the statute, you find a listing, a large listing of physical places, gyms, hotels, entertainment venues, restaurants, all things that are places you have to walk into. And of course, if you have to walk into them, we can start defining what it looks like, right? If the thresholds are too high, or if you don't have handicap spots, or you don't have bathrooms of a certain size, or you don't have railings to help people with physical impairments, those are relatively easy and well developed, right? You have local building codes that will actually tell you what those things have to be in terms of dimensions, in terms of everything. You don't have that with this area of with this issue of websites, because in fact people didn't think that was actually required. Domino's, this Robles Domino's case, what happened in that case, and it's a really easy case to understand, is somebody that was blind or had a visual impairment wanted to use the Domino's Pizza app and said they could not, right? And then Domino's defense was, yeah, but websites aren't covered, only physical locations are covered. And then the Ninth Circuit said, and I think this is correct, the Ninth Circuit said, well, your website helps with access to the physical place, right? In other words, where are you ordering the pizza from, right? It comes from a physical restaurant. And maybe you don't go in there. Maybe somebody delivers it from you, but it's all a public accommodation because it's a restaurant. And a restaurant is described in this statute, in the Americans with Disabilities Act. So you have to provide access to the website. And now you have people saying, all right, that covers everything. In fact, even in my client's case, we've been arguing about, my client has no physical place. He's exclusively online only, right? There's a substantial debate now over, well, if you have no physical place at all, you're not covered by the reasoning provided in that kind of case. But that's what's changed substantially. The only thing I can say, sorry, you have to talk to your lawyer, really, because this is actually a fairly involved body of law. The DOJ, the Department of Justice, has some authority to implement regulations and enforce this. They have not. Mostly, this is not to be political, it's just a matter of fact. The Trump administration has had a very big impetus to revoke regulations, right, as perhaps being business damaging. So they halted a bunch of regulations that were going to get implemented, including this one relating to possibly saying what your website has to do. So there's no guidance there. So monitor the news and get a good lawyer that can help you know if there's risk. And in the meantime, too, I think, yeah, if you go through those checkers and do what Christopher's saying, you might be able to reduce your risk. Again, unfortunately, I think the kind of ambulance chaser, I like that you use that word. I won't hold that back. I think I'm dealing with ambulance chaser lawyers, really. I don't like to denigrate. A lot of people don't like lawyers. Probably a lot of people met me and didn't like me. I try to be respectable. And it makes me sick how much money my client has spent. But on the other, I got to charge my client. I mean, I'm working late nights and stuff to make sure things get filed and he wins. And he's got a good incentive. Wrestle with this for a moment. I'll leave with this thought because I know I've talked a lot here. But they price these things so that it's cheaper to pay them than to pay me in any one particular case. But the numbers are absurd. And I can't tell you what numbers have been thrown around because it's an active case and those things are privileged. But it is an absurd number. If you looked at it, as my client did, the first thing you'd say is, why? Did your client lose that amount of money? No, they didn't. They didn't. All they're doing is they're saying, but you're going to spend that much and more unless you pay me, right? You're going to pay your lawyer that to defend it. And the real hard thing is, if my client were to pay them, it only settles it as to that particular plaintiff. You can't pay off another firm and say, never bring a lawsuit like this ever again, other firm. And there's nothing to stop that other firm from finding another blind litigant to sue you again for something else ad nauseum. So frankly, we need congressional lawmaking. I don't think that's ever going to happen, unfortunately. So, yeah. So that's my piece. Not this year. Yeah.
That's not year. So I actually did have another question for you, and now it's run past my head. Is there a way to legitimately fight this and not spend, 6 or 7 figures?
Yeah, I mean, it's not that, look, it's a 5-figure defense because there are a lot of legal defenses, meaning I don't have to gather evidences and witnesses and do discovery. Discoveries where that's what they're banking on. In other words, discovery is where they send you a lot of invasive requests, right? They can look at your financial records and do all sorts of things that they think are harassing. And there are ways I'm fighting it right now. In my case, the most significant thing I did that really put them on a bad footing is they originally sued us in Los Angeles. A lot of these cases originate in Los Angeles because California has a corollary act called the Unruh Act, UNRUH. I'm not sure if it's Unruh or Unruh, UNRUH Act, and it has something called statutory damage. That means if you lose, you pay a set dollar figure for each offense. The dollar figure is $4,000. And the law doesn't say what an offense is. Is it a single web page? Is it every time somebody visits it? Is it every day it's up? Of course, the plaintiff says, yeah, it's every time I visit it. And ironically, they visit the websites quite a bit, right? So they are demanding, they always demand $74,999 because unfortunately, if they put 75,000 in, that would be, if you have a claim for 75,000 and you have diverse plaintiffs from different states, which is usually typically true, then you can put it in federal court. And from what I gather, the federal judges in Los Angeles are not as favorable to this position as the state court judges in Los Angeles. So they file these cases there, right? And then they basically want to extort a fee. I persuaded them to dismiss it, basically saying, we're going to fight you on being in California because there's nothing that connects my client to California, which probably be true of a lot of people here, that other than the fact of running a website, which is accessible anywhere, perhaps you didn't do any particular marketing out anywhere. And that's a good way to move the case. So I got the case moved to Roanoke, where my client is. And then we got that California claim dismissed altogether. So we're sitting here fighting about the ADA. Now, it was expensive. It's 5 figures, right? It makes sense for my client to do it basically to demonstrate that he's not, most of these law firms want quick settlements. That's what they want. At this point, I suspect they're fighting because they know I'm going to try to get what's called sanctions against them if I win. In other words, I'm going to tell the judge this should have never been in court to begin with, and I want them to, the law firm, to pay money. So at this point, they know they're kind of, the tables are turned, I think, to a degree, and they're fighting for that because if they win on an ADA claim, they don't get any money. They just get at best, they get a court order. And the last hearing I had with this case, the judge was really piqued by the fact of, I asked sort of rhetorically, what kind of order are we going to put? Judge doesn't want to put in an order about what code you're going to put on your website. That's kind of beyond the know-how of, in our case, like a 70-year-old judge, right? So he doesn't want to do stuff like that. So these things can be fought. It is expensive. It is not 6-7 figure expensive. It's 5-figure expensive, and maybe it's cheaper, right? In my client's case, it's, if I set the precedent, we think maybe we've worn off other people. But then, of course, they'll go after somebody in here that doesn't have that case decision. Maybe, I don't know.
So, and that brings up what I was going to ask about before. So my understanding is that outside of requiring remediation, federal court does not allow for damages, but the Unruh does, which is why they're filing in California. Can you explain that difference a little bit?
Yes. So the Unruh Act, but as these things tend to be, California, right, has stronger, let's say, consumer protection laws of this kind. So like I said before, Unruh Act says, and it's a state law, right? So in principle, you'd think, hopefully this gets much deeper and harder if I was talking to other lawyers about, right, the territorial boundaries of a state, but you'd think I shouldn't be subject to the laws of the state of California unless I live in California or I do substantial business in California. In my experience, they don't really care, the people bringing these actions in California. What they say is, well, my client's in California, I access the website in California, so therefore I'm going to sue you under the Unruh Act. And you're right, the Unruh Act says $4,000 per offense. It doesn't say what an offense is, so arguably it's every time somebody accesses it, right? Now, there are some state court judges that have said, no, it's just one $4,000 amount, but it also includes attorney's fees. Attorney's fees are always going to be higher than $4,000 in a case like this. So that's what they're banking on. And you're right. Then the ADA, which is a federal law, which you would argue about in federal court, the ADA is no damages whatsoever. In other words, the plaintiff gets no money. The only money that may change hands is, it says you can get an injunction, means a court order requiring accessibility. And then you may, if the judge thinks it's appropriate, get attorney's fees for the cost of going and getting an injunction. So another common way to defend these, which is cost effective as well, is to render them moot. What that means is whatever they say are the barriers in the lawsuit, whatever coding deficiencies they say are the barriers, fix them immediately, regardless of the merit of them. And then you go to court and say they're moot. They don't exist anymore. So you don't need to issue a court order. And if you don't need to issue a court order, then you can't award fees, right? You only get attorney's fees if you actually got the judge to issue the order. And so that's very helpful. So if you can make it just a federal claim, it's very defensible. And in fact, also there's no real reason for the plaintiff to bring it, right? The plaintiff should only be bringing it in the circumstances that are where we say the plaintiff has standing, where the plaintiff actually cares. It's a business maybe the plaintiff uses all the time, right? A physical barriers type case, perhaps. But unfortunately, these cases are being brought up against any website because the plaintiff can access any website they want at any time without having any relationship with that business up to that point, or even that product that's sold there.
Right. So any recommendation for how often somebody should review their site, assuming they've gone to the trouble and they think they're fairly compliant? Do you have a recommended time interval where they should be double checking and making sure?
I think that's just based on how much. I think it's just based on how often they update their site. I mean, again, if that's one of those static informational sites like Andrew's, he's never changing his site. He's already run it through. Nothing's going to change. So there's not going to be any reason for that. Again, there are some fringe scenarios where if you're on a framework or have heavy reliance on a plugin that gets updated and they may break something that you are dependent on, that's one of those things where the little asterisk is coming into play. You might have to test more frequently. But if you don't have a blog or you don't have something where you're not testing or updating your site very frequently, making a lot of implementations, there's really no reason to be testing it more than once in a blue moon, again, assuming nothing's changing.
I agree. It's not a time interval. I agree. It's more of have you changed something significant?
And to that end, and this may be better for you, Christopher, are there some things that store owners could do today that would, even if it doesn't offer a full solution, might help put them in a better position and get them on the path?
I think just doing their due diligence is going to be the best thing. I mean, again, it's not going to take more than a few minutes of your time to use any of those tools that I linked to, or just pull up a screen reader on your phone, for example, and just go through a quick thing. Put yourself in the shoes of anyone with a disability, visually or audibly, and just kind of do a self-assessment based on whatever those validators spit out. You're going to have a pretty good idea of the gaping holes, and again, the low-hanging fruit that you can easily patch up. And again, that's where most of those frivolous lawsuits are coming to. Like Andrew said, I mean, they're not big usability things. I mean, if they're big, you probably already know about them. It's not something we're having this conversation about today.
Cool. And I want to add a little something. So, for years, people have been basically keyword stuffing their alt descriptions because that was a recommended SEO technique. And the purpose of those descriptions to begin with was to describe what the photo is really about for the sight impaired. So the good news is that if you're doing those correctly, you should still be able to by describing a photo attached to a product, it should still be meaningful from an SEO standpoint. So if I were talking to somebody and saying, what can you do today? Number one, I would look at, and I don't know what the legal language is required, but I would look at putting a statement on your site for people who have special needs and offer up personal assistance to those who can't navigate your site. I would say make sure your alt descriptions are present on all your images, and that includes your template images, which traditionally from an SEO standpoint, you didn't say this is a green button. But you may want to actually get into your theme files and make sure, because I know we were not, if we did a custom made homepage, we were not necessarily alt descripting everything on that page. Now we are doing that as a matter of principle. And then take a look at your videos, because the video is another issue. And there's actually more to it than the captions. There's things like being able to turn them off, so that somebody who is disturbed by the motion isn't getting seasick from it. So there's things that flash a lot can trigger an epileptic seizure. So there's all kinds of things you can get into the nitty gritty. But if you can hit some of these, then, if you get challenged, you could say, hey, we're working towards that end. And would either one of you recommend one of these plugin overlays? Is that still a worthwhile way of showing you're trying?
I've literally never had any experience with it whatsoever. I've never, you guys are literally the first. I mean, I've seen them before, but to me, they're always just more, just click accept kind of thing. I mean, I think more of that could end up in your privacy policy. I think Andrew can probably speak more to that, but I see a lot of stuff in privacy policies, again, more on the political spectrum of the clients I'm working with, where they do cover some of those accessibility, usability considerations. And having a privacy policy is, I don't know if that's legal enough. I mean, defer to Andrew there.
And by the way, I have that plugin on my site if you want to check one out. But we're also finding it broke another site. So
there's always, so what they're, for as far as the code goes, right? Imagine and what these plugins help you do, for example, is one common one. It's in my lawsuit I have that has a little bit more meaning is, for example, right, filling out form fields, right? You don't see it visibly, right? You have this contact form. It says, give me your name and phone number and details about your inquiry, and I'll call you back. And of course it says name and it says details about the inquiry and it says phone number on it. But if you actually look at the HTML or whatever code it is underneath it, you don't actually have, there's these little fields that are hidden that would tell you what kind of data is being accepted in there. And that's a common complaint, for example, and the plugin may fix that, all right? Now, all that said, if you've got, I think as a legal matter, right, it doesn't actually matter, right? If you've got plain text that's going to get read by a screen reader next to the field, you've complied with law. It's not an access barrier. And so I tend to think the real solution, the best defense you have, is to have an alternate site that is stripped of all of this stuff, right? That's like the cleanest text, plain text possible. Depends on the website. My client sells a tangible good, so he can do that quite easily, right? And that's what I would advise clients that I have like that to do. Right now, you're going to have this argument of, well, it harms my personal dignity to use this deprecated site, but I don't think any judge is going to buy that. The judge is going to say, "What's your complaint?" You can buy the good, and in fact, it has to be an access barrier is the thing. These arguments that I've seen that they say personal dignity. I don't want to downplay that. I'm sure it's very difficult to live with disabilities like this. I'm sure it is, but we're talking about realities here of what we can do to make it accessible. The law is about making it as accessible as possible. So I find it almost a joke when a lawyer says, well, now you're making it too accessible because you're targeting the disability of my client. I'm just like, well, that's the whole point of the law, is to help your client in particular that we know has a particular disability. Right? So that's what I would do. Make a dumb site, basically. Make a dumbed down site, with a clean text site.
Well, and I've heard that issue raised too. And one of the arguments I said, but that's what restaurants do. If they have stairs in the doorstep, they've got an alternate entrance with a ramp or an elevator, right. Because there's no way to make the staircase compliant.
Right. Absolutely. Or if you go into the bathroom, right, there's often a special handicapped stall, and there's nothing wrong with that. That's a good thing, right, as a society, that we've gone out to help the less fortunate of our group so that it can fit in as a railing and all of that, right? But as space considerations, if you had all stalls like that, well, that's not practical for business either. You need to have smaller stalls too. So I think that's plainly the law. And there's actually there were actually interesting enough, there were debates when Congress passed this law in the early 90s. And one of the odd things to see an anachronism, if you remember Blockbuster Video, right, which Doesn't exist anymore. But Blockbuster had an attorney represented at these hearings Congress is having, and they basically said, we're really worried. We're really worried because we are worried that if this passes, then we have to offer videos with closed captioning. And imagine at that time, it wasn't automated like it can be now. They would have had to produce a bunch of new videos with closed captioning. It would have been very expensive. And the retort from the Congress men and women that were drafting this law said, no, we're just talking about access to the goods and services. We're not requiring you to modify the goods and services themselves, right? So, if people with certain disabilities can't use them, that's unfortunate perhaps, but that's not what this law is intended to do. And I think that's very important to remember as well.
Cool. Well, we're kind of up on the time limit here, guys. I want to thank you. You've both been fabulous. I will say we are going to post this video it'll get sent to those who have registered through either Eventbrite or Meetup. I will post it on YouTube as well. And if you want to ask questions, we have the Austin Retail and E-commerce Meetup Facebook. Typically that's open to residents of Texas, but I think AJ would be cool with us expanding that a little bit to those who are attending our seminars. So if anybody else has a last minute question,
We're
anything
getting
you guys,
we're getting a
I
lot
was
of
good.
thank yous, but they're all coming to me because the Zoom chat is set up that way. So thank you guys so much on behalf of everyone listening in today. A lot of people said they're getting very good food for thought to go over and to think about for their own stores.
Yeah. Thanks for having me. This was interesting, fun.
Awesome. And
Thanks,
for anybody who wants either one of these gentlemen's contact information, feel free to reach out to me and I'll make sure you can have it.
Absolutely.
Take
Thanks
care.
again for the opportunity. It was a pleasure, Lori and AJ. You guys Andrew, it was a pleasure meeting you.
Nice meeting you. Chris.
Meeting you. have a fantastic week, everyone.
All right. Take care, everybody.
Sure.
Thank you.
Bye.